Hello everyone, welcome to Analog IAS. In this video, we'll be continuing our discussion on the jurisdiction and powers of High Court in India. We have already discussed some of the original jurisdiction and the supervisory jurisdiction of the High Court. In this video, we'll be discussing about the other jurisdiction of High Courts, that is control over the subordinate courts. The main provisions are the governor of a state has to consult the High Court for the appointment, posting and promotion of the district judges and also to the appointment of persons to the judicial service of the state. And the High Court can withdraw a case from a subordinate court if it feels that the law or the case involves an interpretation of the constitution which the district court cannot be taken into consideration because of lack of jurisdiction. The law is binding on all the subordinate courts functioning within the territorial jurisdiction. On the similar way, the acts which are pronounced by the Supreme Court are applicable to the High Court and to the subordinate courts as well. The next jurisdiction or powers is the Court of Record. That is, the judgments, proceedings and acts of the High Court are recorded for perpetual memory and testimony. Therefore, these are given the status of an act which have the same power as those legislated under the state legislature. And it also has the power to punish for contempt of the court either with simple imprisonment or with the fine or with both. The point to be noted here is the contempt can be divided into civil and criminal. That is, even though they are not provided explicitly in the constitution, the act, that is Contempt of Court Act of 1971, provides guidance to the court to decide what is a civil and what is a criminal contempt. That is, if a person or an authority scandalizes or lowers the authority of a court, or prejudices or interferes with the due course of judicial proceedings, or obstructs the administration of justice in any manner, it is termed as a criminal contempt. Else it is termed as a civil contempt. The last power is the power of judicial review. Even though explicitly the term judicial review has not been mentioned anywhere in the Constitution, provisions such as Article 13 and Article 226 of the Constitution explicitly confer the power of judicial review on a High Court. Therefore, the High Court can examine the constitutionality of legislative enactments and executive orders of both central as well as the state governments. Now let us solve this question. Consider the following statements. High Courts have no contempt powers. High Court can declare a central law, please note it, this is central law, null and void if the law violates part 3 of the Constitution. The correct answer is B2 only. As we have already discussed that High Courts have the contempt power, that is both civil and criminal, according to the Contempt of Court Act of 1971. Therefore, statement 1 is wrong. Statement 2 is correct because High Court can declare a central law null and void. Here, the point to be remembered is part 3 of the Constitution deals with the fundamental rights of the citizens as well as non-citizens. Therefore, the correct answer is B2 only. Thank you.